Good morning. We are now recording and on the record. I will note that the official record for today is the video recording of this Microsoft Teams meeting. You may see that the Teams automatically creates a transcript of the meeting, but this is not an official record of the hearing because the transcript is not an accurate recording of the testimony. So the transcript will not be referenced as part of the record. There will not be a transcript of this hearing, and only the video recording will be the official record. We are convened today to hear the case of Susan Bertrand versus County of Dane, ERD case number CR 2022-02424. Today's date is February 19, 2025, and the hearing is taking place by Microsoft Teams video conferencing software. My name is Calvin Fermin, and I'm the administrative law judge assigned to hear this matter. The hearing was set to begin at 8:30 a.m. It is now 8:40 a.m. I'd ask that the parties please state their appearances, beginning with the complainant. Please state your name and spell it for the record.
Susan Bertrand, SUSAN BERTRAND.
Appearances for the respondent.
Melita, MELITA, M. Mullen, MULLEN, appearing for the respondent, Dane County.
All right, and I believe is there a representative for the respondent?
Yes, I have also here Elizabeth Peterson as a representative.
And what is Ms. Peterson's role with the company?
She is the general curator. Oh, sorry. She is the general curator at the Vila Sioux.
Okay. Thank you.
And I guess I would want to inquire before we go further whether Ms. Bertrand has a representative present as well.
Oh yeah, I do apologize, Ms. Bertrand. I believe you do have a representative present.
Yes.
Yes.
And if you can state your name, sir.
I'm Ben Ratliff. It's BEN. Last name's RATLIFFE.
And then in what capacity are you representing? And
I'm the field representative for council, for AFSCME Council 32.
Okay. Thank you.
Yep.
All right. To summarize the procedural history of this case, I note that the complaint was filed on September 6, 2022. An initial determination was issued on May 13, 2024, finding no probable cause to believe that the respondent violated the Wisconsin Fair Employment Act by discriminating against the complainant in terms or conditions of employment because of sex, by discriminating against the complainant in terms or conditions of employment because of pregnancy, and by discriminating against the complainant in compensation because of pregnancy. The complainant appealed the initial determination on June 12, 2024. Accordingly, a pre-hearing conference was held with the parties on August 1st, 2024, where the parties set a date for the hearing. Today is therefore a hearing on the issue of probable cause to determine whether there is probable cause to believe that the respondent violated the Wisconsin Fair Employment Act as alleged. The complainant bears the burden to prove probable cause to believe that the unlawful discrimination occurred and shall present her case first. The respondent then will present its case. The opportunity to present rebuttal proof will then be given to both parties. At this time, we will have opening statements, starting with the complainant.
Good morning, Your Honor, and thank you for being here today. I, Susan Bertrand, am representing myself in the matter of discrimination in terms and conditions of employment because of sex and pregnancy. The Wisconsin Fair Employment Act requires that employees treat pregnancy as it would treat other medical restrictions not related to pregnancy. Dane County Zoo Management did not treat me in the same manner as they treat other temporarily disabled employees. They did not provide me with the same job assignments as they provide other zookeepers with light-duty restrictions. If every zookeeper with a 20-pound weight restriction had to work the carousel, we wouldn't be here today. However, no other zookeeper has been assigned to work the carousel. Why was I treated differently? I started working at Henry Vila Zoo in November 2018. I had a good working relationship with zoo management for nearly 3 years. In August of 2021, I asked to leave the primate cat building. The work environment had become toxic. I felt the stress working in the primate building was negatively affecting my health. I was trying to get pregnant for more than a year. Management allowed me to discontinue working in the primate section of the building immediately. However, they asked me to continue working cats until they could train another employee for coverage. In good faith, I agreed. 4 months went by. I followed up with management. They told me that I needed to get accommodations from the ADA. I learned that Dane County employees have an employee advocate, Shannon Meyer. Her job is to help mediate conflicts between management and employees. I did not want to file a grievance for fear of retaliation. I felt mediation was a better option. Employee advocate Shannon Meyer informed zoo management that they have to treat all employees the same. If they allow zookeepers to choose where they want to work, they have to allow me to do the same. After this meeting, I was removed from cats. Unfortunately, bringing HR to the zoo destroyed my relationship with zoo management. Shortly after leaving the primate cat building, I became pregnant. When my doctor gave me light duty restrictions, I was very concerned. I told her that I was not allowed to have restrictions at work. She told me that for pregnancy, I am. I was still concerned. Dane County Zoo Management has a history of retaliation and discrimination. Zoo management moves zookeepers out of animal areas as punishment. Zookeeping is an emotional job. Zookeepers form bonds with the animals they care for. When management informed me that they wanted to have a meeting, I knew they were going to remove me from animal areas. I asked Shannon Meyer, employee advocate, for support. I was informed in the meeting with management that I had to join the Stay at Work program. Elizabeth Peterson told me that she felt working the carousel would be the safest place for me. She also stated it would make her feel better. Elizabeth Peterson said that she was afraid I would lift something that I should not lift if I continued to work in animal areas. She made me feel that I was no longer permitted to enter animal areas. She made a point to say that she did not need restrictions when she was pregnant, implying that my restrictions were not necessary. I was removed from all animal care duties on July 26, 2022. I was required to work in less favorable conditions, creating more stress and greater risk to my pregnancy. I emailed everyone I could think of asking for help. April Kiaga, Dane County Board of Supervisors, contacted Judge Bailey Wren. The judge contacted zoo management. Elizabeth Peterson notified me that I could assist the ambassador animal zookeeper. The animals had been recently moved into the guest services office where I was permitted to work. I was not scheduled as a zookeeper caring for the animals. I was only able to assist. These duties were in addition to working the guest services and working the carousel. Management knew this move was very upsetting to me. They knew they were causing me unnecessary stress during my pregnancy. I repeatedly expressed concerns to management about the move to carousel. The move was not safer. In fact, the position was more harmful to my pregnancy. This position required prolonged sitting, forced me to work in extreme heat, caused higher exposure to COVID-19, and forced me to exceed my weight restriction. Dane County management has allowed zookeepers with doctor-imposed weight restrictions to continue to work as zookeepers. Management could have allowed me to continue to work as a zookeeper. Instead, they chose to use my weight restrictions due to pregnancy to retaliate against me. Dane County Henry Viola Zoo management used my pregnancy as a reason to take adverse action against me. They treated me less favorably than other temporarily disabled employees. They enforced additional restrictions on me. They reduced my job responsibilities. They gave me a less favorable job assignment and relocated me to a less favorable work location. I hope that I can prove that to you today.
Thank you. Opening statements, Attorney Mullen.
Yes. My name is Melita Mullen. I represent Respondent Dane County, which is responsible for the operations at the Henry Vilas Zoo. Dane County is here at this probable cause hearing to defend the fact that it kept complainant Susan Bertrand fully employed and fully compensated while she had temporary medical restrictions imposed by her healthcare providers during her pregnancy. Dane County treated Ms. Bertrand the same way it treats all non-work injured employees with temporary medical restrictions. It gave her light duty work at her usual rate of pay when she could not perform all essential functions of her job as a zookeeper. Ms. Bertrand told her employer that she would only be able to lift 15 pounds in the last trimester of her pregnancy. When the zoo gave her a temporary light duty assignment in the guest services area, she objected because she preferred to continue working with animals. Neither the Wisconsin Fair Employment Act nor the Pregnancy Discrimination Act entitles pregnant workers to preferential treatment. No zookeeper, pregnant or not, with temporary lifting restrictions or not, ever has the privilege of choosing their scheduled assignments on a weekly basis or their specific duties each day. The evidence will show the following. Ms. Bertrand was one of 17 zookeepers at the Henry Vilas Zoo. All zookeepers have the same job description that requires them to work in multiple areas and to repeatedly lift up to 50 pounds unassisted. The job description also requires zookeepers to work other duties as assigned in addition to the identified duties. On March 24th, 2022, Ms. Bertrand informed her manager that she had both current and prospective restrictions. She was at that time not able to work in cats or lift more than 30 pounds. She also said she would not be able to lift more than 15 pounds after July 3rd, 2022. In conversations with Ms. Bertrand, zoo managers agreed that Ms. Bertrand could continue to work in her assigned areas through the end of June with her 30-pound restriction. However, zoo and county managers had to plan for July when her lifting restriction would drop to 15 pounds. Scheduling zookeepers across multiple areas is complex and depends on multiple factors that are not limited to zookeeper preferences. At the zoo and throughout the county, workers injured at work may have opportunities for light duty work while they have medical restrictions. Those light duty assignments may or may not be in their typical area of work. In addition to the workers' compensation system, Dane County also has a separate program called Stay at Work that provides light duty work for workers with temporary medical restrictions that do not arise from a work injury. At a meeting in May 2022, zoo managers told Ms. Bertrand about the Stay at Work program. The Stay at Work program allows temporary modifications to an employee's duties subject to availability and feasibility of work at the manager's discretion. The Stay at Work program allows participants to maintain their job title and rate of pay during the period of temporary modification. The zoo managers plan to assign Ms. Bertrand to guest services when her restrictions changed, but Ms. Bertrand expressed a preference to keep performing animal care in specified areas, by which I mean areas that she specified. To delay the start of the light duty assignment, Ms. Bertrand got a new medical note that kept her 30-pound restriction in place until July 21st, 2022. On July 21st, 2022, she provided a medical note indicating she was now restricted from lifting more than 20 pounds consistently instead of 15 pounds as previously indicated. Starting on July 26, 2022, she was assigned to guest services. Through her 2 months on light duty and guest services, zoo managers balanced Ms. Bertrand's lifting restrictions with her desire to work with animals by assigning some tasks involving animals. She remained on light duty and guest services until her child was born in late September. Her pay and schedule did not change at any time during her pregnancy. The evidence will show that all zookeepers with lifting restrictions, whether from work injuries or not, have a paid light duty option at the county. For zookeepers, sometimes light duty work is with animals and sometimes it is not, depending on the restrictions and operational needs. The light duty assignments are made at the discretion of management to balance these operational needs and permit workers to continue working within their restrictions. In fact, the evidence will show that the zoo seeks to keep zookeepers in the areas of their preference when possible, but the evidence will not show that any zookeepers have the privilege of picking and choosing among work area assignments or specific tasks, as Ms. Bertrand asserts she should have been able to do. At the conclusion of the hearing, I'm confident that you will find there is no probable cause to believe that Dane County discriminated against Ms. Bertrand in the terms or conditions of her employment because of sex or pregnancy.
Thank you. I will note that Mr. Anderson is on the platform. Ms. Bertrand, is he going to be your first witness, or is he just here in preparation?
He was just making sure his teams worked.
All right. Is he going to be leaving the platform? Is he going to be staying on the platform?
Oh,
I would ask that he leave the platform, as he's not a representative.
Okay.
Yeah, so he can join when it's going to be his turn to testify.
Okay.
Is he in the room with you right now?
Yes. Does he need to
So I
leave the room?
think Attorney Mullen is also going to want him not to be present in the room. Is that correct, Attorney Mullen?
Yes, that is correct.
That's
So
fine.
not
Sorry.
uncommon, right, for witnesses to be sequestered so that we know that their testimony is their testimony.
Okay.
All right. I will note that the parties have entered into stipulations. Let me go ahead and quickly put that up on the screen here. So Attorney Mullen sent this to me and Ms. Bertrand shortly before we went on the record. The stipulated facts contain a total of 7 facts. I know, Ms. Bertrand, you had a chance to review it, and you are agreeing to the stipulated facts, Ms. Bertrand?
Yes.
And then Attorney Mullen, the respondent, is agreeing to these stipulated facts?
Yes.
All right, so then these facts will be admitted as facts and placed into the record, and the parties obviously may reference them as appropriate, but they need not lay any foundation or reintroduce them. So go to stop sharing. So, Ms. Bertrand, you're going to be your first witness.
Yes.
If you can please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, you can lower your hand. We already have your name on the record, so you can begin with your testimony.
Okay. I was just gonna go through the exhibits as I have them listed. Is that appropriate? My exhibit 1.
All right, so I will start by saying I typically would share the screen myself. Is your preference that you share the screen with the exhibits, that we're all on the same page, or do you want me to still share the exhibit?
You
And
can
then
share
we'll
the exhibit
follow.
if you want.
So then let me go through. All right, it should be on the screen. So you're saying you're starting with exhibit 1.
Yep.
Are you going to be here? ERD 002?
Okay. Yes. This is an email from Zoom manager Joanna Soto on August 23rd, 2021. This email is asking which zookeepers which areas they prefer to work in. Says if they want to become a primary, continue as a relief keeper, management as zookeepers, if they prefer to work in areas, and also lists all the animal areas that we have. It does explain that weekends will split things up differently to ensure appropriate coverage. So that was just one example of showing management asking zookeepers what areas they want to work in, showing that they do allow preference. So it is not unusual for someone to express areas that they want to work in. Exhibit number 2 on page ERD 008 is another email from Joanna Soto on October 26, 2023.
So I object to this exhibit
Okay.
on the grounds that the date on here is October 26, 2023, which is like a year after the events involved in this complaint. I would also object to this as hearsay and irrelevant to any issues in this case, as it, again, this email is from 2023.
What are you attempting to show with this, Ms. Bertrand?
It was just another example of similar to the first example where management is asking zookeepers where they want to work for their preferred areas, and just showing that it is not unusual for zookeepers to ask for preferred areas. So
All right. So this is an administrative hearing. We can accept hearsay testimony. uncorroborated hearsay can't be used to prove a material issue, but we can't accept hearsay testimony, so I won't reject it for that reason. As for the time frame, I think it's going to showing examples of this type of behavior. So although it is after the fact, it doesn't look like it's meant to show the discrimination. So I'm going to allow it as an exhibit.
Just have a question.
Yes.
How is it an email from management hearsay?
Well, so I mean, I guess you can come back and ask or make an argument that it's not hearsay. Now, generally speaking, hearsay is an out-of-court statement, right, being used to prove the truth of the matter asserted. I guess you're trying to say it's admission by a party opponent potentially, so which is not hearsay, or that there's exceptions. Now, generally speaking, the party would say that. I'm not excluding it on the hearsay grounds. And it doesn't look like it's necessarily going to a material issue, right? She's trying to show examples of when they have asked for preference. So I'm going to accept it for that reason. But to the extent that I was going to exclude it, I guess those would be your arguments. You're either going to try to say it's admission by a party opponent because it's management. Obviously, at the time, I don't know that it's management necessarily. But it's not being excluded for hearsay reasons, so we don't need to address that.
Thank you for the explanation, Your Honor.
Yep.
Okay, exhibit number 3, starting on ERD 014.
So I will, let me just go ahead and pause since we're going to go through. I'm assuming your intention is that all of these exhibits are going to be moved into evidence.
Yes.
Is that correct? All right, so then we can take them as they come along. So C1, Attorney Mullen, any objection to it being admitted?
To which one? C1?
C1.
No objection.
Okay. C2, I know you made some initial objections. Any other objection to them being admitted?
No, not to
Okay.
not to exhibit 2.
All right, and now we're on C3. Okay, go ahead, Ms. Bertrand.
C3 is an email chain with the Dane County Corporation Council discussing an alternative assignment. And then that also includes my doctor note to delay restrictions. So this is from Amy Tutwiler, Assistant Corporation Counsel. Hi, Shannon. I'm writing to follow up on our discussion yesterday. I understand that Susan objects to the attached assignment plan, which was created to accommodate the 15-pound restriction her doctor has ordered. The current plan accommodates the restrictions her doctor imposed and addresses her stated desire to remain active. Nonetheless, what I heard is that she believes her condition constitutes a disability and that she seeks a different accommodation than the one she has been given based on past treatment of other employees. Her position raises legal and factual issues that need to be investigated. Susan will be assigned as outlined in the attached plan until the investigation process is completed and her request for alternative accommodation can be addressed. I wanted to include this because obviously it discusses that I asked for another accommodation. Also, I was under the impression that, further discussions were going to be had. And to my knowledge, they never met to discuss alternative assignments that would be accommodating. Let's see.
As to this portion, I want to object. I mean, Ms. Bertrand isn't copied on this email. She hasn't laid any foundation for us to how it came into her possession. Or so, and in addition to that, it's also hearsay. But I understand that hearsay can be admitted in some circumstances. But as far as this particular email goes, it's unclear how this email came into her possession.
Okay.
Ms. Bertrand. Yep.
Yeah. This is an email chain, and so it is. I am later CC'd into the email. I think because it looks like Amy Tutwiler emailed Shannon, and then when Shannon responded, she added all of the rest of us. She added Elizabeth Peterson, myself, and Eddie Sherman, Rhonda. So that's how I was included in it.
But she also hasn't called any of those people as witnesses to lay the foundation for this document.
Yeah, that is technically true. Miss Bertrand, do you have that full email chain?
Yeah, I have. Yep, the entire email chain is on the following pages, and then it shows that's also where my doctor's note.
Are you saying within the packet, the following pages?
Yeah, it goes
So-
out to ERD 017. So that was
you're-
just
Okay, 1 second.
Okay.
So this was. Okay.